Garnett Show will inspire and empower you, giving you the tools to build your brand. It's a new day for a new way to bring your vision to pass. Another day, here to recreate. The Akia Garnett Show, teaching strategies that you need, empowering you to succeed. She has a plan to help build your brand. Oh yeah, if you wanna go far, she'll take you from where you are. She's here to motivate, here to recreate. The Akia Garnett Show, inspiration, motivation. The Akia Garnett Show, creation, reformation. The Akia Garnett Show, dedication, expectation. The Akia Garnett Show.
Hello, hello, hello. This is Akia Garnett, your host for the Akia Garnett Show. Thank you for listening in today. I'm so glad that you are going to be listening as I have a conversation with Mr. Todd Pilot, Esquire, who is an attorney and counselor at law. Now, let me tell you a little bit about Todd. Todd is the managing member of the Trademark Institute, a business, entertainment, and intellectual property boutique located in Old Town Alexandria, Virginia. Mr. Pilot provides artists, athletes, entertainers, producers, writers, filmmakers, new and established businesses, nonprofits, and events managers with specialized contract, business litigation, and intellectual property advice, assistance, and representation. Trademark law, copyright law, contracts, entertainment, and licensing issues are Mr. Pilot's primary practice area. Mr. Pilot has a bachelor's in physics from Virginia Commonwealth University and a master's degree in physics from Hampton University. He began his career in technology and the sciences with research and engineering positions at NASA and IBM, respectively. In 1994, Mr. Pilot received his law degree from the College of William and Mary Marshall Witch School of Law, where his focus was technology and intellectual property. Following law school, Mr. Pilot clerked in the D.C. Superior Court for senior judges Luke Moore, Margaret Haywood, Bruce Mincher, and Ronald Wertheim, and thereafter Chief Judge Eugene Hamilton. Following his clerkships, Mr. Pilot worked for the U.S. Department of Commerce as a trademark attorney. He has represented a number of artists, writers, and producers in the music industry and has negotiated numerous recording deals and production deals with major and minor labels. Mr. Pilot represents television and radio personalities and has negotiated a number of radio, TV, and motion picture contracts. He also provides legal assistance to television networks, independent record labels, event planners, concert promoters, movie producers, and writers. He has literally worked on more than 1,000 trademark applications and numerous matters before the Trademark Trial and Appeal Board. He is a frequent speaker on trademark, copyright, entertainment, and small business matters and has been active with the Old Dominion Bar Association, Black Entertainment and Sports Law Association, the National Bar Association, the Alexandria Bar Association, and the Virginia State Bar Disciplinary Committee. Mr. Pilot is the president-elect of the Alexandria Bar Association, the first African American to be elected to this position in the Bar Association's 80-year history. Hello, hello, Todd Pilot. How are you?
Good afternoon. Bracing for the snow.
Yeah, aren't we all? I'm so glad to have you on as my guest today. I know that trademark and copyright and patents and all those great things are something that baffles a lot of people. I think a lot of people feel that they know the law, but sometimes they may not truly understand what everything means in terms of their own intellectual property and how to protect it, and also how to build their legacy, whereas in the years to come they won't have a challenge with maintaining property or ownership of what they've put so much time and effort into building. And so I'm so glad that you've agreed to do the ABCs of trademark law with me today on the Akia Garnett Show.
Well, I thought we were doing protecting your brand.
Well, that is what we're doing because it's all wrapped into branding.
No, you're right. You're absolutely right. A trademark is the basis of branding. So.
Yes. Especially when we set it up right in the first place, then we can really have a lot of freedom over how we brand ourselves in the future. So let's just jump right into how you actually decided to go into law, because from your bio there's just so many great things that you've done, especially with the mention of NASA and also the mention of IBM. So how did you get your start in law?
That's a good question, and it's actually a more seamless transition than perhaps it appears on paper. I went to law school to focus on patent. Intellectual property is broken down into three sections: patent, trademark, and copyright in general. There's some smaller sections within that umbrella, but those are the three main areas. And so in order to do patent law, you have to have a technical degree, chemistry, physics, engineering, math, something like that. And so, believe it or not, it's not unusual for lawyers who do patent law not only to have, say, a bachelor's in chemistry, but perhaps maybe a master's or even a PhD. So that was my primary focus in terms of going to law school, was to focus on patent law. But I went back to NASA and found myself working working in the patent office there, and found the other aspects a bit more interesting to me, the trademark and the copyright matters. And so I just decided to focus on to place my primary focus on the trademark and copyright matters as opposed to the patent matters. We still do the patent work, but my focus is primarily on trademark and copyright.
So when you went in, was that just something that was unexpected in terms of you having an interest in a trademark as time went by, or was that something that you kind of thought maybe?
Well, it is. I'll be honest with you. I was working on this patent over at NASA, and it was so completely and totally boring. I fell asleep doing it, and I said to myself, I can't. If you're gonna, when you're planning your life and your career, I've always, said that you want to do something that excites you, that you're interested in, and that's gonna, that's gonna keep you excited. That's the case when you put the time into it. And I think you put the time in anything, you're gonna be good at it. It doesn't matter what it is. And if you're good at something, you'll make money, and that's what we're ultimately here to do. So yeah, it was a bit unexpected, but I think when I got my first job at a firm in Virginia Beach representing artists and athletes and entertainers, it was just a lot of fun, and represented a big change in terms of where my career was headed.
Okay, great. And then I noticed, I want to jump to the end of your bio here, where it's you were the first African American to be elected to the Alexandria Bar Association. How was that? How did that happen?
Oh boy, Alexandria is a wonderful city, and Alexandria, Virginia, is just an incredible city. It has
that's great. I mean, naturally, throughout our conversation, we're going to be talking about the legal assistance that you provide to television networks and record labels and event planners, because that really, when it comes to small business nowadays and everybody who is building a brand, they all have some sort of representation of themselves online, on television, on radio, and so they can take their brand nowadays very far with the advent of technology. And so I think we're going to spend the bulk of our time now talking about how you are helping small business owners and entrepreneurs build their brand legally the right way, and in a way, of course, that allows them to continue building without so much exposure long term when it comes to borrowing, or sometimes not fully out of ignorance, understanding that you're really infringing upon someone else's brand or someone else's intellectual property. So just to go into the topic a bit more, can you tell us, in your mind, what, and according to the law, of course, what is intellectual property and how trademark law applies to that?
Okay. It's property. You've got real property, you've got tangible property, you've got intellectual property. Real property, we are all familiar with that. That's that dirt that your house sits on. Land. Tangible property, is, anything that, you can touch or feel, the watch, the ring, your furniture. Intellectual property is, those assets are not tangible. That brand, that trademark, that copyright for a book or a song, the patent for an invention, one's performance rights, the likeness, one's likeness, that's all considered intellectual property. So in the context of your business clients, I know that your focus is helping to brand them, helping to grow them, helping to basically create a space out there so that people know who this company is and what they do. And that's what that brand represents. And so, we're all familiar with some of the more famous brands. They change, but Coca-Cola is still considered one of the strongest brands in the world. And Google is a very strong brand these days. Any one could name any of the cars, Lexus, Chevrolet, and soft drinks, Pepsi. Talked about Coca-Cola and the others. You've got brands, computer companies like Google, IBM. So those are the brands.
Yeah.
And so those are your brands. That's how we would describe intellectual property. And every good business is going to have a brand or have a mark that represents their brand. And it's something that, that business is going to want to control and protect. And so we come in on the protection side. Once you've identified that brand, they've sat down with you and you guys have come up with a good name that represents the company and what they're trying to do. And you'd probably come up with a nice logo. And then it's our job to protect it. And so the first thing that we would do is we go out and we do what's called a trademark search to see if it's available, or determine whether or companies and potential acquisitions. And if you think about it, what really, most companies don't have anything else but their name.
Yeah.
You know what I mean?
Yeah.
Everybody can make donuts. Everybody can, make hamburgers or provide
consulting services.
Yeah, everybody can provide. Difference maker is the company that has created a reputation for providing superior goods and or services under a particular name.
So let me ask you a question regarding intellectual property and trademarking and so forth. If there's a company that's been operating out in the public domain with a particular name, and it's very clear. Say, for instance, it's McDonald's, and say, for instance, they didn't have any protection around their brand, but they've got stores all over the place. I mean, McDonald's, it's associated with the Golden Arches. You know what their menu is. You can sing some of their songs. But say they had never gone the legal route to protect their brand. Is it something that has to be done in order to say this is mine, or does the public domain at all have any weight when it comes to a company that has been building a name and using a particular brand and experience, but then, kind of gets sidetracked because there is someone else who wants to pop up and in that same space begin to claim some of that territory?
Right. Well, I think that's a good question. McDonald's, let's make this, let's clear the record. McDonald's, you were just citing that as an example, but of course we know that McDonald's intellectual property is protected.
Yes.
They're very diligent about protecting their intellectual property. And it's not unusual for, folks to come out and try to do something that's similar to one of the McDonald's trademarks, and McDonald's goes after them like there's no tomorrow.
Yes.
But I get your point, where a company goes out and does business and doesn't take the steps to create, to protect their intellectual property. What happens there? And the answer is that if you use a mark and you use it in commerce, then you acquire what we call common law rights. And so, and that happens sometimes where, let's say, a company is using, let's say, a catchy name in Dallas, Texas. And, they've never taken steps to protect it. And another company is using the same name in New York, and they take steps to protect it. Not only protect it, but they start to branch out and franchise it and do more.
Yeah.
They don't even know about the company in Texas. Well, what would typically happen is that the company in Texas might be able to retain the right to use that mark in the geographic area where it's using it, like Texas.
Okay.
And so we'll call that the senior user, because that senior user was using the mark first. But that junior user who went out and registered the mark and started using it could actually acquire superior rights to the senior user. And so the junior user could acquire the exclusive rights to use that mark everywhere else but in Dallas, Texas, where the senior user started using it first. And so one of the reasons that you actually want to protect your trademark in this instance is to keep someone else from acquiring superior rights over you. But there are common law rights that kick into play, but they're very limited in geographic areas, whereas when one acquires a federal trademark, it's good throughout the entire country.
Okay. So then the actual, and I don't say the legal definition to a point where it becomes something that people really can understand, but can you give us in dummy terms what the legal definition for trademark is, so that people understand, well, here's what this really means.
The legal definition of a trademark is those are rights conferred by the government that gives you the exclusive right to use a particular mark in connection with particular goods or services. So, for instance, when you actually get a trademark for your business or product offering or what have you, it's tied to those particular goods or services for which you secure the trademark. So let's say that you have a client who is going to go into business providing, let's see here, providing car detailing. And so the trademark would be tied to that car detailing service. And they'd have exclusive rights to use that trademark throughout the country. And if someone were to use that mark after they've secured that trademark registration, they would be committing trademark infringement, which could subject them to fines, fees, having all of everything with the trademark on it destroyed, treble damages, which is basically triple damages, all the profits. I mean, the damages can be immense.
Yeah, and so for trademark, then what would you say? Because they don't want to go directly into violations, because I'm sure there are just so many case studies of that. But what are some ways that people can at least have a quick cheat sheet in terms of what is a list of things or something where people can say, well, here's how you know that you're taking the right steps to protect your brand. And I know sometimes, people they'll start a company before they even get the notion that, they probably need to talk to an attorney. Some people, they start their business, of course, in a garage. They're not thinking about, protecting their brand. They don't even know they have a brand. So, what about for the company who's out there? They've already been operating. They're just building away, and they're not thinking about, tomorrow and whether or not, they're operating with the same name as someone else. And that, what can you offer in terms of a quick list of ways that you know that you're moving toward needing to chat with an attorney?
Well, when you start making money and you start getting big, when you start a business, the first thing you want to do is probably, get your business set up. We used to say incorporate, but we don't say that anymore because incorporate means that you're going to form a corporation.
Yeah.
Be a corporation, maybe an LLC. In fact, more likely it's going to be an LLC. So the first thing you want to do is get your business set up. Why do you want to do that? Because, one of the primary purposes for setting up a business is limiting one's liability. And so, because you go into business does not mean that if it doesn't work out, you should lose everything. And so these businesses, have their own identity. Yeah. And so any debts incurred, should be limited to the assets of the business. So that's really the first thing I think that folks want to do. And if they have a little bit more money and want to make sure that they're operating under a name that they can go under, that's probably not a bad idea at the early stage. And that's because who wants to go out there and create goodwill or build a brand? That's what you're doing here. Create all this goodwill under this name, only to have to learn later on that you're going to have to change it. Goodwill is, it's like, people having to get to know you by a different name. That's expensive.
Yes,
it is. I mean, it's expensive, and so, those are two very important steps early on in the process. issues have become a bit more sensitive and taken on a heightened importance over the course of the last 10 years than they were before. I mean, folks always had trademarks and it was always important. But the importance of this has been heightened over the last 10 years because of the internet.
Yeah.
And what happened is that you may have been operating a hamburger joint called Mickey D's in Illinois that nobody knew about before the internet.
Oh, yeah.
But now everybody knows because of the internet.
Yeah.
You don't even have to put your stuff on the internet anymore. Other people will do it.
I mean, just in the last, month or two, there's been two separate stories on companies that have tried to set up a little Starbucks-like brand and have been shut down.
And that's the purpose of the penalties in that way, because it's very common for people to want to trade off of successful businesses. Very common. Very common. A lot of people don't even realize that that's illegal. But it's very common, and that's why these people police their brands. They know that if you go out there and call yourself something that's similar to a known brand, that you're going to get business.
Well, and the funny story from Coming to America, the movie with Eddie Murphy, and how the character John Amos was branding McDowell's after McDonald's, and
Right.
I think that was my first. I think that was my first introduction to someone who could really move so close to a brand, but try to differentiate it, even though it's so obvious that they are stealing.
That's right. We call it passing off.
Yes.
Yes, and and companies don't like it, and they, and for good reason. I mean, I've represented companies who, hired me to go after people who were using their name or a name that was confusingly similar, because customers were calling these companies and using these companies. I represented a huge limousine company in the Washington, D.C. area, because there was another company that had gone out and, and placed this company's name in its meta tag such that
Wow.
when someone went on the internet to look for my client's company, they would find this other limo company. And this other limo company was, like two guys in a truck. They had two limos and a couple of guys, and people were using this company thinking they were using my client. And they had bad experiences. And so they would say, "Oh, I'll never use them again."
Yeah.
So the victim of those bad experiences was my client.
Yeah.
And so they had to shut it down.
So what's the technical term? What is the legal term for that?
Trademark infringement.
Okay.
So that company got sued for trademark infringement.
But you mentioned just a second ago passing off, and what exactly is that?
Passing off is the McDowell's in Coming to America. They're passing off. They're trading off of the McDonald's today.
Yeah. Okay.
Well,
how long do those sort of things? How long can they be tied up in court? I know that's an open-ended question.
Most people, most people will if they're smart, they're going to just get it settled quickly.
Yeah.
Others will, because it's very expensive, because all of this stuff ends up in the federal court. Trademark law the trademark, copyright, and patent, are federal issues. So the cases always end up in federal court. So let's say that you, this happens all the time. You get a cease and desist letter. You got an angry letter from a company. Let me see here. Let's go use some real life examples. Over the last year, Delta Sigma Theta was celebrating their 100th anniversary of Columbia.
Yeah.
And, the Deltas had carefully planned some incredible events and licensed the use of their name for some other events, and so that's a valuable right that they have. Now, in Washington, D.C., whenever anybody comes, everybody likes to pass off. Or basically lie and say, hey, this is the official Delta party.
Yeah, I get it.
And Delta wasn't having it. And so the Delta Sigma Theta went after a bunch of these folks who were running around, doing these events, using Delta Sigma Theta's name without Delta Sigma Theta's permission.
Yeah.
And, some of those affected, had to deal with it accordingly.
Yeah.
But they were not playing, and, they had a law firm that went after these folks, and they shook the tree.
And how quickly can action be taken? I mean, when you say things like that, and you've got, say, an event that's coming up in 10 days, and you've got someone who's diligently looking out for the brand and mentioning of the brand.
They'll fire a letter off within a day. They'll fire a cease and desist letter off, and if you go forward with it, then you're probably going to have some problems.
So you're really dealing with the cleanup, right? Your damages afterward, right? Or are you would that organization still probably just kind of obnoxiously keep doing what they're doing until they're really in court?
Well, some folks are like that. James, some folks, take the position they don't think that you're serious.
Yeah.
They will continue to infringe upon the mark and force the trademark owner to sue them.
Yeah.
And then they realize how serious it is.
Yeah.
And they call a lawyer, who does this type of work. And that lawyer is going to tell them, sure, I'll represent you, but I'm going to need a $15,000, $20,000 retainer.
So then, because
they realize how serious it is.
I mean, so then when you have, a brand that is, kind of in a space where there is just so much stiff competition, and it's a very popular industry or so, how can you carve out a unique name, and aside from, some of the things that we do, which is,
Well, that's a good question. That's a really, really...
Yeah, how do you do that so that you really are operating in your own space and it's very clear?
Well, and this is where, this is the advice that we give to you, branding people that sit down with your customers to come up with names.
You branding people.
Because that was a very good question, and very important issues that you all have to consider.
Yep.
What you have to consider is, what can I protect? What can I protect? What has the most protection?
Yes.
And so trademarks, they come in about 3 different flavors. There's the descriptive, which we consider almost generic. And then there is the, I would say the coin term that has no meaning whatsoever.
Yeah, like the Google and Yahoo and.
Right. Yeah. And then in the middle is the what would you call the suggestive?
Yeah, like.
Yeah, you're right. Google, Yahoo, all those Xerox, Lexus. Those marks are coins.
Yes.
They don't mean anything really. And so they're entitled to the highest degree of protection. On the other end of the spectrum is the descriptive mark. Washington Gas. People like we call that geographically descriptive. People like to take geographic moniker and add another descriptive term to it. Those marks are going to be afforded the least amount of protection. Folks want to set up business and try to send the message that they're global, and so you're going to see global this, global that all over the place. Yeah. Sorry, people, not that strong. Lots of amount in global descriptive. Things like that. And so, if you want to build a strong brand, think to marks that are not descriptive. We didn't talk about Apple. Apple's not descriptive. It's not as bizarre as Google or anything like that, but it's still not descriptive.
question that it belongs to.
No, but people want to give their business a name that immediately conveys what they do.
Yeah.
And what I suggest is that you can still use the descriptive terms. That's why, the trademark office will not allow someone to get a trademark for consulting services.
Okay.
Period. Is that everyone needs to be able to use those terms.
Well, is that like because I advise, or sometimes when I'm teaching on this topic from a branding perspective, I use Netflix as an example. It's on the internet. When you think flicks, you think movies or films, and so what goes into would it be something like that?
Well, let's talk about Netflix, because that's a good example of it's not out there like Google or Coin, which it means nothing because it actually means something. And it's not completely descriptive like Washington Films.
Yeah.
But it's probably closer to what I was calling suggestive. Because net is kind of shorthand for the internet. Mm-hmm. And flicks is a slang term for films.
Yeah.
And the combination, is just a new term altogether.
Yeah.
So you take, because it's not net space flicks, it's Netflix, all one word.
Yeah.
That changes the character.
Mm-hmm.
And so that is a very strong mark.
Yes. Now, is that something that you'd say would have the highest level of protection?
Not as high as a Google. But I'd say pretty strong because you can also build up protection in a brand, and the smaller businesses aren't going to be able to do that early on. But the reason that Washington Gas and American Airlines and U.S. Airways can have these descriptive names is because they spend millions and millions of dollars advertising and building the brand.
Yeah.
And so, so you can take what is a descriptive mark and spend millions of dollars on it and build that brand.
Well, that was my question for you. When you see people, organizations such as the bigger multi-billion-dollar firms, of course, they're spending millions on marketing campaigns and branding campaigns. And they'll fight to the end legally to protect their names. But what do you see as an average amount of money that a small business or mid-sized business firm can end up spending on fully protecting themselves and limiting their own liability?
Well, the cost outlay is not expensive at all. I mean, if you do the 2 steps, i.e. get your business incorporated and get your trademark, you're probably going to do that for less than a couple $1,000s. And if you don't have that, you might not be ready to go into business yet. You might want to take a little bit more time to save a little bit more money to get that dream started. But a small business is nothing but a big business waiting to be launched. I mean, let's go back. A lot of these businesses that we're familiar with today weren't in existence 10 years ago.
Yeah.
And and the investors, who I work with, they're going to require that you have these ducks in order. I can't tell you how many deals didn't go through because, I'm talking deals where, small businesses, folks have gone out and created a good business.
Yeah.
And, somebody wanted to buy it or invest in it and realized that they didn't own the intellectual property. They hadn't taken those important steps. And so, in essence, they didn't own anything.
Yeah.
But, you take a GoDaddy, for instance. It exists 10 years ago. Investors come in, but you got to own the GoDaddy. You got to own the domain name, and you got to own the contract, the trademark. Great name, fantastic name, and so and with a couple of Super Bowl ads, with investor money, it's a household name.
Yeah.
So a small company is 2 steps away from being a big company, and so you got to be ready when the train comes. You got to have your luggage.
Yeah.
And and I can let you go back home and pack.
That's good. And there's no backward motion, right?
You can sometimes, you can sometimes go back after the fact and try to secure the intellectual property, but it's too late. It's already gone.
Yeah. I mean, one of the things I talk about sometimes is once something is out in the public domain, it becomes hard to then harness that thing in.
Well, people, again, everything, we're all on the internet now, whether we like it or not.
Yeah.
We do it on the internet, whether we like it or not, whether we put it there or not. And so, people may see a good idea that you're doing, look it up, realize that you haven't protected, and say, hey, look, can I get that? And if they come to see me, I'll say, I think you can.
Yeah.
Because that person may have rights in their narrow geographic area.
Yeah.
But if they haven't secured federal trademark protection, that does not give them rights throughout the country. And so, I can honestly tell my clients, what the law says.
Well, and then when you have small businesses now and entrepreneurs who are published and they've got podcasts out there, they've got ebooks out there, they've got video pieces out there, they've got their brand out there scattered in ways that, are much more modern. It becomes even more important to make sure that you understand, exactly how to protect the various ways that your brand are.
That's right. What you described just a minute ago would be subject to copyright. We'll have to have another discussion.
Yeah, I'd definitely love to have you back on to talk about copyright protection. And also, just to talk about basic business and getting started and how you know which business model is best for you legally. And I know that that's a question that I get a lot from small business owners. What should I do? How should I form? And of course, I refer them out to legal counsel. But I think that.
Oh, you mean the business entity discussion?
Yep. The business
entity
discussion.
Place of entity. It really depends. But we're starting to see more and more folks. At least over the last 10 years, doing LLC. But it really depends. We have a lot of clients who are physicians, and the S corp model might be a better fit for some of those. We can actually set up an LLC and have it taxed as an S corp nowadays, and so that might be. But it really depends. I think it's good to sit down with one's attorney and or accountant to help figure that out, because aside from the issues with respect to limiting one's liability, the largest issue becomes tax. Yeah. And how you're gonna have that entity tax.
Yeah. And aside from talking to you, Todd, is there a resource that you can point people to if they have any questions about trademark and where to get started or how to even understand the concept?
That's a good question.
You can always just point them to you and your website or your phone number if they have any questions. I don't want to leave people hanging if they've got.
Oh yeah, sure. By all means. I'm T Pilot at trademarkinstitute.net. I think other resources. I think the trademark office website may have some general information on trademarks, and then from time to time there are various forums that folks will do. I know I've done many of them, and I see them from time to time in the Washington D.C. area, and I send them in other places. Business forums that one can attend.
Awesome. Well, great. Well, thank you. And again, we're going to have folks. We'll have Todd back on again in the future, and we're going to cover some other legal topics that are important for small business owners to be aware of. As a brander, I spend a considerable amount of time talking with attorneys like Todd to make sure that I understand what the implications are for brands that I'm helping my clients build. And so I strongly suggest that as you are building your brand, that you are not just doing it in a bubble, but that you are running your ideas and your questions by legal counsel to make sure that in the long term you will not only be able to see your brand, but also be able to sustain it. I want to thank you, Todd, for your time and for giving us the advice and the information that you gave us. And we will certainly be in touch, and I look forward to having you on again on the Akia Garnett Show.
Well, that's good. Thank you for having me, and make sure that you bundle up tight and get ready for the storm.
Well, thanks a lot for that. Here on the Akia Garnett Show, we know that business can be really personal. And this is why I have partnered with Teresa Caldwell of NewVisionNewLife.com. She will be joining me during the month to talk about business being personal. And we'll take a few minutes to remember how we should and often should fill our own cup so that we can pour into our customers, clients, and anyone else we feel that we serve. Now, many of you may remember Teresa Caldwell from her past work as longtime producer and substitute host for WHUR's The Audrey Chapman Show, as well as co-host for Minding the Heart on HUR Voices, Sirius XM, Channel 141. Teresa, this month, you want to look at the pull of the past. What do you mean by that?
Hi, Akia.
Hey.
Welcome to the month of March.
I know that March is a great and many splendid things. It says that spring is coming. It says that we're, leaving the winter finally, and this has certainly been a serious winter, so I know many people are excited about that.
Oh, my goodness, I know.
As I've already said earlier in the show, it's also the beginning of Women's History Month.
That's right. That's right. And Black History Month just ended. And so it's a time when a lot of us are really looking at how things are going to bloom, not just in the world around us, but in our own lives and our businesses and all of that stuff. But this month, when we say the pull of the past, I want to know what you're saying to yourself about your past. That's important because what we're saying to ourselves about our past indicate how we're living our present, how we're running our present, how we're running our business, how we're running everything that's of value to us. And then as a result, that dictates the course of our future. So there's the past that's always pulling on us. It's always pulling on us, Akia. That's what I mean by that.
Yeah, wow. And this, when it comes to the past, there's, our professional past, there's our personal past, there's our past of our family. I mean, there's so many ways in which you can take the concept of past tense. Which one do you mean specifically?
Well, see, it can all be sort of balled up together inside us, like a big ball of twine or yarn. Remember those rubber band balls that we used to always have together? I guess elementary school teachers probably still do that. They have it on their desk and sometimes they throw it at you or whatever.
Yeah.
So I'm thinking about an example like this. Say in your mind there's often this concept of, well, I don't have or I can't find the time to fill in the blank. So maybe in the past, as recently as yesterday, you felt that was true. So starting right now, what we're going to do is shift the premise you're operating from. So instead of concentrating on what you don't have, the time, that's something that you always said in the past, concentrate on what needs to be done and what resources you have that can get you there. So remember, what we focus on grows. Where you put your energy, that's what you get more of. So the more you say what you don't have, in this case, time, the more you don't have it.
Yeah.
And the opposite's true. So if you focus on what you do have, say it's a challenge that must be handled or a project that's got to be completed, think of it as kind of a riddle to solve. Then you open yourself more to your ability to solve it. When you're open more like that, then the solution can sort of show up for you. Does that make sense?
It does make sense. And I have a question for you regarding the past, and sometimes people, do you think that people are unable to move away from the past because they really haven't dissected it. They haven't articulated what's happened in their past. Kind of, sometimes if there are some real challenges in the past, there's been, sweeping of it under the rug. Maybe it was traumatizing. Or you've got some people who have had a very successful past and they haven't seemed to figure out how to leverage that in the future so that they can maintain whatever successes that they've had. How do you feel about people needing to actually come to terms with what their past was and recognize it for its power, at that time, but also recognize it as being over and the need to continue moving, regardless if that past was a wonderful heyday or if that past was traumatizing?
Well, Akia, I like to give assignments. So I think that an assignment in this case is called for because the main issue becomes the recognition of the past, be it what you would describe as negative or positive or what have you, those dreaded learning experiences. So here's the assignment. Listen to yourself over the next 24 to 48 hours. Which statement do you repeat that has the pull of the past? The concept of, oh, I don't have time for that. Where does that come from? That's not something that just happened. Something inside you, something you automatically say is usually how it shows up. Well, I don't feel like it. Something like that. Listen to yourself over the next 24 to 48 hours. Reframe it based on the issue you have to face, and then do your thing. So that's the first thing we're going to do. The assignment, our current assignment, is to listen to yourself over the next 24 to 48 hours. Which statement do you repeat? And just identify how, when, why it has the pull of the past.
Oh, that's a great assignment. And thank you so much for sharing that one, Teresa. We will be talking about that assignment on Facebook on my public profile page. You can go there as early as today to see the actual assignment and keep checking back in on the page. Add your thoughts and your comments on how you are moving through the assignment, and we will come back and review some of the things that we see on the page, and also Teresa will give us some tips on how we can move forward when the pull of the past continues to call us.